All rise. The Honorable District Court for the Northern District of Imperial is now in session. The Honorable Carla McMillan presiding.
Thank you. You may be seated. All right, my name is Carla McMillan. I'll be presiding over this championship round of Khalif versus POWA. And the first thing we're going to do is start with the oral argument on the motion to exclude. Is the plaintiff ready?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right. Before we go forward, I'm going to briefly remind the parties of today's procedures. Each side will have a total of 10 minutes to present their argument, with the possibility of up to an additional 2 minutes in courtesy time that the court may award at its discretion. You will each have 90 seconds to present your argument without interruption, after which I may question the parties. Counsel for Plaintiff Khalif as the moving party will present first and may reserve up to 4 minutes for rebuttal. The jury is constructively absent for this portion of the proceedings, so please address the court only. And timekeeper for the plaintiff, are you ready? Are you present and ready to proceed?
Yes, Your Honor.
Okay. Timekeeper for the defense, are you present and ready to proceed?
Yes, Your Honor.
All right. When time expires after each side's 90-second introduction, both of you please stand quietly and prominently display your time cards. Do not verbally call time at that point unless I fail to acknowledge you after 10 seconds, which I'll do by using a thumbs up. When time expires for the main argument, please stand and verbally say stop. Do you understand and agree to abide by this rule?
Yes, Your Honor.
Yes, Your Honor.
Okay. And I may grant courtesy time for each side up to 1 minute per argument. Immediately upon the expiration of any courtesy time, you are required to stand and verbally call time. Do you understand and agree to abide by this rule?
Yes, Your Honor, I do.
Yes, Your Honor.
All right. Counsel for Plaintiff Khalif, you have the opportunity to present a rebuttal today. Do you wish to do so?
Yes, Your Honor. I'd like to reserve 2 minutes of my time for rebuttal.
Okay, thank you. Timekeepers, please stand and notify the court after 8 minutes, leaving 2 minutes for the counsel's rebuttal. All right, I think we're done with the preliminaries. Counsel for the plaintiff, you may proceed.
Yes, Your Honor. May it please the court. The plaintiff moves to exclude Exhibit 30 as the fruit of an unconstitutional search and an unconstitutional seizure. Now, Exhibit 30 was Merrick Khalif's therapeutic diary. While in prison, Merrick developed post-traumatic stress disorder. As part of his therapy, the prison psychiatrist told Merrick to write his private-most thoughts in the diary. But on October 3rd of last year, a prison guard entered Merrick's cell with the alleged purpose of finding drugs. When the guard found no drugs, she conducted a violent strip search that revealed the therapeutic diary. Now, the guard read the diary, first to herself and then aloud to other inmates. The guard seized the diary. In their opposition brief, opposing counsel tried to argue that they are somehow immune from the Fourth Amendment. However, we need not respond to that argument because this court has already ruled that because the prison is a state actor, the Fourth Amendment absolutely applies to them.
Counsel, does your argument rely on the fact that this is a strip search? I mean, if I find it's not a strip search, don't you lose your argument?
Yes, Your Honor, I understand the question. If Your Honor was to find that this wasn't a strip search, my argument would still prevail because it was still an unlawful seizure under De Giuseppe versus Ward. May I proceed with my argument?
Yes, you may.
Now, instead, today we're going to focus on 2 points. One, the search that violated the Fourth Amendment was conducted on October 3rd. And second, the seizure of the diary violated the Fourth Amendment. Let's start with point 1. Defendants violated Merrick's Fourth Amendment rights when their guard conducted a violent strip search. Now, we concede that the guard had the right to search Merrick's cell based on an anonymous tip that Merrick had drugs. We also concede that when the guard saw an object in Merrick's pocket, she had the right to ask him to produce it. But that's not what the guard did. Quote, Officer James observed Merrick's behavior. He noted that the packet resembled a package of drugs and asked Merrick if he was hiding drugs in his pants.
But counsel, I haven't heard any facts showing that this is a strip search. I mean, what is it? I mean, the guard didn't go in there intending for a strip search, but to look for drugs, and discovered that Mr. Khalif was hiding something in his pants. I mean, isn't the guard entitled to search at that point?
Yes, Your Honor. Now, the plaintiff holds that this was a strip search, and I'd like to address your question in two prongs. First, the reason there was a strip search. Now, in opposing counsel's brief, they actually repeatedly state that there was a strip search, if I may read. On page 4, opposing counsel wrote, Officer James asked Khalif to remove his pants. Then opposing counsel wrote, Officer James then ordered Khalif to strip his pants. A few lines down, Officer James then attempted to pull down the pants. Your Honor, clearly this was a strip search as written in opposing counsel's own brief. Now, the reason that this strip search violated the Fourth Amendment was because it was abusive. May I proceed into that argument
Yes, you
and answer
may.
your question? Now, we can see what constitutes an abusive strip search in the Sixth Circuit case Studemeyer versus Michigan Department of Corrections. There, like here, an officer conducted a strip search of an inmate in the presence of other inmates.
But counsel, wasn't that a more egregious circumstance where the inmate was left in their underclothes in front of all other inmates? The inmate was particularly vulnerable because he was in a wheelchair. I mean, isn't that totally different than this case?
Yes, Your Honor, I'm really glad you asked that. Now, I'd like to address why the strip search here was actually more invasive than the strip search in Studemeyer. Now, the distinctions you brought up are absolutely valid, and it's true that she was stripped all the way down to her underpants. However, in today's case, the effect of the strip search was the same on Mr. Khalif. He was still humiliated. The intent was the same on the part of the police officer. So we can see a similarity there. Now, the reason that, according to your question, the strip search was more invasive in this case was due in part to the fact that Officer James used force. There in Studemeyer, the officer never used force. But here, Officer James took a baton and thrust it against Merrick's throat so hard that it caused bruising and an inability to breathe. And furthermore, why it's more invasive in this case as opposed to Studemeyer is because there the justification was unclear, but here Officer James wanted to embarrass Merrick, an inmate who filed a grievance against him before.
Well, counsel, before you go to your rebuttal, can you address why the exclusionary rule should apply in this civil case?
Absolutely, Your Honor. Now, in order to decide whether or not the exclusionary rule applies, we must look at the deterrent effect versus the social benefit of excluding the evidence, as outlined in INS versus Lopez. Now, we have to take that test one at a time to determine whether or not the exclusionary rule applies. Now, first, here the deterrent value is immense. Prison guards confront the boundaries of the Fourth Amendment literally every day. They have the keys to every inmate's cell, and they have the difficult task of balancing Fourth Amendment civil liberties with the duty to preserve law and order. Now, Your Honor, this makes them much more like police officers, whose conduct always implicates the exclusionary rule. In fact, because of the frequency with which prison guards must confront the Fourth Amendment, there is an enormous deterrent value in excluding evidence when a prison guard violates the Fourth Amendment. Now, to address the social cost part of the balancing test outlined in INS versus Lopez, there's almost no social cost in this case to excluding the evidence precisely because this is a civil case. Unlike in a criminal case, exclusion of the diary does not risk a criminal going free. Unlike the immigration officers in INS versus Lopez, exclusion of the diary does not allow anyone to remain in this country illegally.
But counsel, in a civil case, we're trying to get to the truth here. The exclusionary rule is counter to that, right? I mean, why should we apply the exclusionary rule in this case when, in the discovery process, this would have been certainly discoverable information.
Absolutely, Your Honor. The reason that we should apply the exclusionary rule in this case is because the deterrent of that effect is immense, and it's against the party that needs to be deterred, police officers. Even if the diary was discovered, and it would have been discovered by civil discovery, the fact remains that Fruit of the Poisonous Tree under Bell versus Wolfish establishes that the original seizure of the diary was invalid and violated Merrick's Fourth Amendment rights. Because the prison guards violated the Fourth Amendment at the beginning of the search, their conduct should be deterred. The only way to deter that conduct is to apply the exclusionary rule.
But shouldn't I apply the inevitable discovery doctrine and say, well, they would have discovered it anyway, and so it should be let in?
Certainly, Your Honor, that would be up to your discretion. But plaintiff holds that you should apply the exclusionary rule because when applying the test from the case law in INS versus Lopez and again in US versus Janus, the social cost of excluding the evidence is very low when compared to the deterrent effect. May I briefly wrap up my argument?
Yes, you may.
Thank you. Now, in sum, we have established that defendants performed 1, an unconstitutional search, and 2, an unconstitutional seizure, which 3, requires the application of the exclusionary rule. Now, the Fourth Amendment states, quote, "The right of the people to be secure in your persons, houses, papers, shall not be violated." Eric Khalif was a person. His house was that tiny cell, and his papers were that private diary. Because defendants violated Merrick's Fourth Amendment rights, we ask that you exclude Exhibit 30. Thank you.
Counsel. All right, are the defendants ready to proceed?
Yes, Your Honor.
All right, you may proceed.
May it please the court. My name is Gabriel Pena, counsel for the defendants Meg James and Prisons of Western America. Your Honor, the defense respectfully requests that you deny the plaintiff's motion to suppress information obtained from Merrick Khalif's personal diary. This diary contains admissions by Mr. Khalif on important issues in this case and is essential for the jury to make a proper judgment in this case. Your Honor, the defense asks that you deny the plaintiff's motion for the following 3 reasons. Number 1, the diary was obtained in the course of a properly conducted search and seizure while in the course of looking for evidence of a drug smuggling ring within the prison. Second, the prohibitions against unreasonable searches and seizures delineated in the Fourth Amendment do not apply to the specialized circumstances of a prison cell. And number 3, excluding this diary from evidence would not further any deterrent evidence of future official misconduct. Your Honor, the evidence and admissions found in this diary are of substantial value to the defense's case, as well as to the jury's ability to hear the evidence fairly and accurately determine a just and proper outcome. Your Honor, the search of Mr. Khalif's cell, person, and diary was entirely justified given the circumstances of this case. In this case, Your Honor, Paua had experienced an increase in drug smuggling and drug-related violence. Their investigation showed that inmates were organizing and smuggling. And furthermore, a confidential informant pointed out Mr. Khalif as instrumental in this context. Although opposing counsel has cited Bell v. Wolfish in their argument, the court in that case held that, quote, "The legitimate goals and policies of the penal institution limit constitutional rights." Your Honor.
Well, counsel, but there's no question that the prison authorities were permitted to search for drugs. I mean, there's no question about that. I mean, the question here, in my mind, is it seems that under the facts of this case, the motivations to search went beyond that. It went to humiliate, because otherwise, I mean, why was a diary being read aloud? And if that's the case, then I don't see how the Fourth Amendment would protect the search.
Your Honor, we do agree that Meg James did cross the line when reading the diary out loud, but we contend that the search of the cell of Merrick Khalif's person and his diary leading up before the reading out loud of the diary are all constitutional, and therefore the evidence should be admitted into this trial.
Okay, but if I find that the reading of the diary was unconstitutional, should I exclude it?
No, Your Honor, because the initial obtainment of the diary and the searching of the diary was all constitutional under Diagoose Bay v. Ward, which held that the inspection and confiscation of an inmate's personal diary did not violate their Fourth Amendment rights.
Well, counsel, but can I consider the fact that the officer read the diary aloud and some of the other things that she said and determined that there's a bad animus for the search, and it wasn't really to search for drugs, it was for this other reason?
No, Your Honor, because the initial search of the cell was for drugs. And in the cell, after Meg James had conducted the search of the cell, he began to cover his pocket, which prompted Meg James to try to obtain the diary. Once he obtained the diary, he proceeded to look through the diary for any evidence. We do believe that Meg James did possibly cross a line when reading the diary out loud. However, once again, the initial search leading up to that was all constitutional.
Now, counsel, in their opening argument, plaintiff contends that defense has conceded this is a strip search. Do you concede that?
No, Your Honor. We do agree that Meg James did try to obtain the diary. However, we do not believe that the pulling down of Mayor Khalif's pants constituted a strip search. Your Honor, a strip search by its very nature is extreme intrusion upon personal privacy. While we do agree that Mayor Khalif was exposed, we do not believe that it reached the level of a strip search. Your Honor, in addition, although the plaintiff has emphasized the fact that Mr. Khalif was subject to a strip search, once again, the search of Mr. Khalif's person did not reach the level of a strip search. Your Honor, the plaintiffs have relied on Stoudemire v. Michigan Department of Corrections in arguing that the search of Mr. Khalif violated Fourth Amendment rights. However, as the opposing counsel said, the facts of that case was entirely different. Your Honor, in that case, an inmate was fully exposed to the public and her clothes were fully removed. Unlike in our case, Mr. Khalif's clothes were not fully removed and he was not fully exposed to the public without reason. Your Honor, once again, opposing counsel mentioned INS v. Lopez Mendoza. The court in that case noted that in the civil cases in which the only instance in a civil case in which the exclusionary rule of the Fourth Amendment can be justified is when there is a need to deter future unlawful misconduct. Your Honor, in our case, there is no future unlawful misconduct to deter.
Well, isn't the unlawful conduct, if I were to find that the search was unreasonable, I mean, wouldn't it, and I exclude that evidence, that's the future conduct that I would be deterring?
No,
right?
Your Honor. The defense holds that the circumstances in which occurred in Mayor Khalif's cell were extremely unique. We do believe that routine searches are common in prison. However, in cases, there are rarely incidents in which personal belongings are taken from the prisoner, and therefore the cases are unique.
I find it hard to believe that there aren't a lot of cases out there where prison officials take personal things out of a prisoner's cell. I mean, it could be a diary, it could be a letter from their lawyer, it could be a multitude of other things that are seized in violation of the Fourth Amendment. I mean, why isn't this that kind of case?
Because, Your Honor, looking back at the evidence in this case, we can see that the obtainment of the diary was constitutional, and it was unique to a point in which it is unlikely to happen again. Your Honor, in all the cases cited here today, including those cited by the plaintiff, there's a recurring theme, and that is this: that the rights and privileges enjoyed by ordinary citizens are for the most part inapplicable to specialized circumstances of a prison cell. Your Honor, confinement by its very nature results in the curtailment of rights. Meg James and the prison had every right to search the cell of Mayor Khalif because a presence of a drug smuggling ring within the prison cannot be tolerated. Your Honor, going back to Bell v. Wolfish, the court in that case held that prisons are able to curtail the rights of inmates in order to maintain internal order and security within the prison. Your Honor, in our case, Mayor Khalif's cell was searched for drugs because any drug harboring would threaten the internal order and security of the prison. Your Honor, the courts have been clear that the Fourth Amendment does not apply to the specialized circumstances such as in this case. Your Honor, and for these reasons, we ask that you deny the plaintiff's motion and admit the diary and its contents into evidence.
All right, thank you, counsel.
Thank you.
Rebuttal from the plaintiff, Your Honor.
Yes, you may proceed.
Your Honor, I'd like to address the question you asked opposing counsel. You said, the question here to me is that the motivation went beyond the scope of the search. Now, Your Honor, that's absolutely correct. In this case, the motivation for the initial search of Merrick's cell, which we conceded was lawful, did not go beyond, did not extend to the strip search. Now, Your Honor, I'd like to address a couple points opposing counsel made in determining why that motivation went beyond the scope of the strip search. Now, first of all, opposing counsel stated that the reading of the diary did not violate the Fourth Amendment.
But counsel, just one question. I mean, there are a lot of cases under the Fourth Amendment where we've said that the officer's subjective belief in the situation doesn't affect whether the search was unreasonable. And we look at the objective circumstances. I mean, why should I go behind the search here and look at the motivation?
Excuse me, I don't quite understand your question. Are you asking me to address the objective motivations of the police officer
Yes, the
specifically? in
objective
this case?
motivation. I mean, why should I get behind? Why should I go behind the objective motivations of the police officer and look at the subjective reasons why this officer may have disliked Mr. Khalif or tried to harass him?
Absolutely, Your Honor. Now, the plaintiff holds that even if the reason you should look at the subjective understanding of the police officer is because under Florence versus Board of Chosen Freeholders, we're looking at what a reasonable officer would do. So that is an objective test, but the subjective decisions of the officer play into that. Your Honor, may I briefly conclude before my time expires?
Yes, you may.
Yes. Your Honor, because defendants performed a strip search under their description in their opposition brief, Your Honor, this strip search violated the Fourth Amendment as well as the seizure. We ask that you deny, that you exclude Exhibit 30. Thank you.
Thank you. All right, in this championship round, we're not going to break to confer with the judges, so thank you very much to both sides for your arguments. I found each of you to be persuasive. However, based on the arguments in the briefing, I'm going to exclude the diary in this case.
Yes, Your Honor.
All right, thank you. All right, so I think we're ready to proceed. Would the plaintiff like to introduce themselves and their witnesses?
Yes, Your Honor. Good morning, Your Honor. My name is Audrey Shepard. Today I represent the estate of Merrick Khalif. I'm joined by my co-counsel, Morgan DeVico,
Good morning, Your Honor.
Jeremy Judd,
Good morning, Your Honor.
and Ellie Ford.
Good morning, Your Honor.
After the defense has stated their appearances, we have a few preliminary matters to address, Your Honor.
Yes, I'll take that up after the introductions. Thank you. All right, are the defendants ready to proceed?
Yes, Your Honor.
All right, so if you could proceed with the introductions.
Good morning, Your Honor. Members of the jury, opposing counsel, Victoria Nia for the defense.
Good morning, Your Honor. Christopher Cordero for the defense.
Good morning, Your Honor. Valerie Nia for the defense.
Good morning, Your Honor. Gabriel Pena for the defense.
All right, thank you. All right, we'll proceed with the preliminary matters now. We'll start with the plaintiff.
First, we'd ask freedom of the courtroom during statements and examinations on behalf of both parties.
Yes, you may.
We'd ask, Your Honor, how you'd like us to approach witnesses during this case.
You can ask to approach, and then you may approach. And as far as your exhibits, I don't know if there's a table, maybe at this table right here in the front where you can collect the exhibits.
Perfect. And then, Your Honor, plaintiff has brought exhibits 1 through 48. We've pre-marked them as such for the purposes of this competition.
All right.
And we'd also like the record to note that we've brought several demonstrative aids. Opposing counsel has reviewed them before the trial began.
Okay.
With that, the plaintiff is ready to proceed, Your Honor.
All right. Thank you. Let me see if the defendants have any Any other preliminary pretrial matters they'd like to take up?
Your Honor, we have exhibits and one demonstrative that we have shown to opposing counsel before the beginning of this trial.
Okay, great. All right, I think I'm to have the plaintiffs announce their 3 witnesses. Are you ready to announce who your witnesses will be?
Yes, Your Honor.
Okay.
First plaintiff will call Harry Khalif, then Frank Lynn, and then we will call psychiatrist Hawkison.
All right, and then same question for the defendant.
For the defense, we will first call Meg James, then Patton Schreier, and finally Dr. Iran.
Okay, terrific. All right, and we'll consider that the witnesses have been sworn in for purposes of this competition, all right? All right, I think we're ready to begin with opening statements. Plaintiff, are you ready to begin?
Yes, Your Honor.
Okay, you may proceed.
To them, he was worthless. It's December 24, 2016. It's Christmas Eve. Merrick Khalif's family is huddled outside trying to keep warm. They hear a loud buzz. They see the huge metal doors sliding open. They see a silhouette walking towards them. Their son, their brother, is finally coming home. But when they see his face, they know that something's not right. They're all crying. They go to him and tell him how much they love him. But Merrick? His face is blank. They swarm him with hugs. They put their arms around him and tell him that they've missed him. But Merrick's arms stay at his sides. That's because even though Merrick Khalif is a free man, he still thinks he's inside of that tiny cell. He still thinks he's in solitary confinement. Afraid. And alone. The evidence will show that Merrick Khalif never recovered from solitary confinement. That when he got out of prison, he walked to a bridge. And he jumped. But members of the jury, the evidence will also show that the death of this 18-year-old young man could have been avoided. Merrick's psychiatrist told the prison again and again that he couldn't handle any more solitary confinement, that what he really needed was treatment. But the prison? They said no. No, that's too expensive. Because to them, Merrick was worthless. As the plaintiff, Merrick's father, Harold Khalif, is suing 2 defendants. Prisons of Western America, a corporation that runs private prisons around the United States, and one of their officers, Meg James. Now, we've brought 4 claims involving civil rights violations and 1 claim of wrongful death. Now, at the end of this trial, the judge will explain the law to you, but for now, there's 3 things that you need to know. This is what we have to prove. First, the defendants knew that Merrick Khalif was in danger, physically and mentally. 2, the defendants showed deliberate indifference. They chose not to help Merrick. And 3, that deliberate indifference caused Merrick's injuries, caused his depression, and it caused his death. We have to prove these facts by a preponderance of the evidence, more likely than not. We'll meet this burden by proving that to the defendants, Merrick Khalif wasn't worth protecting, and Merrick Khalif wasn't worth treating. First, we'll prove that Merrick Khalif wasn't worth protecting.
Today you'll hear from eyewitness Frank Lynn. He was an inmate with Merrick, and he was his friend. He'll tell you that when Merrick was jumped by a prison gang, Officer James just stood by and watched. When that gang started beating Merrick, kicking him, stomping his head into the ground, Officer James just stood and watched. When that gang was done with Merrick, the prison sent them back to their cells. But then they sent Merrick, bruised and bleeding, to a month of solitary confinement. Second, we'll prove that to the defendants, Merrick wasn't worth treating. Now, today, you'll meet Dr. Singh. Dr. Singh was the chief psychiatrist at the prison. Dr. Singh will tell you how traumatic solitary confinement is. An 8x10 room, 22 hours a day, no windows, no showers, no human contact at all. She'll tell you that for fully grown adults, solitary confinement is devastating. But that when the prison first threw Merrick in solitary, he was only 17 years old. You'll hear that because of his experiences in solitary confinement, that he developed a psychological disorder. Dr. Singh will tell you that she pleaded with the prison to take him out of solitary confinement, to give him therapy, but that the warden said, no, that is way too expensive. You'll hear that Merrick spent 90 days in solitary confinement. Dr. Singh will tell you that it was this trauma, those nightmares, those flashbacks, that depression, it was that trauma that caused him to take his own life. Members of the jury, 1.5 years ago, in a courtroom very much like this one, Merrick Khalif stood and pled guilty to giving marijuana to a friend. Because it was his third marijuana offense, the judge had to give him a more severe punishment. But that punishment was supposed to be a 6-month sentence, not a death sentence. That punishment was supposed to send Merrick to prison, not to a life of fear, beatings, and solitary confinement. Today, the evidence will show that when the prison told Merrick that he wasn't worth protecting, when they told him that he wasn't worth treating, he decided his life wasn't worth living. That's why at the end of this trial, we'll ask that you find the defendants liable. Because to them, he was worthless.
Thank you, counsel. Is the defendant ready for opening statement?
Yes, Your Honor.
All right, you may proceed.
Members of the jury, the plaintiff just told you a story. They told you Merrick Khalif was sentenced to prison, that he had run-ins with other inmates and prison guards, that he sustained physical injuries and mental health problems, and that after being released from prison, Mr. Khalif tragically took his own life. And that's all true. But as you will learn today, that's only half the story. And we're going to tell you the other half. Yes, Mr. Khalif suffered from physical injuries in prison, but what the plaintiff didn't tell you is that in both altercations, it was Mr. Khalif who threw the first punch. Yes, Mr. Khalif committed suicide as a result of his post-traumatic stress disorder. But what the plaintiff didn't tell you is that he developed this disorder long before he entered prison from a childhood of abuse. Now, today, the plaintiff will ask you to blame the prison on Mr. Khalif's injuries, his suicide. But once you hear the other half of the story, you will see that this correctional institution is not the one at fault. Good morning. My name is Victoria Nia, and I represent the defendants in today's action, Officer Meg James and Prisons of Western America. As the defense, we bear no burden of proof. We don't have to prove a thing. And that's because the plaintiff has the burden. They have to prove every element of all 5 of their claims by preponderance of the evidence, more likely than not. But there's one element common to all of their claims, all 5 of their claims, that they will not be able to prove, and that's causation. We admit the prison wasn't perfect. Officer James wasn't perfect. But whatever mistakes the prison made weren't the real cause of Mr. Khalif's injuries, and certainly not the cause of the plaintiff's decision to commit suicide. And we will show that by telling you the other half of the story. First, we will tell you the other half of what happened inside of those prison walls. Today, the plaintiff will call one eyewitness, one who will testify to 2 incidents in which Mr. Khalif was hurt. But the evidence will show Mr. Khalif was no innocent victim. Mr. Khalif was a 3-time convicted criminal. Mr. Khalif was an aggressor. And you will hear this from 2 of our eyewitnesses today, Officer Meg James herself and prison inmate Patton Schreier, and they will tell you that before Mr. Khalif was injured by another inmate, it was Mr. Khalif who threw the first punch. Before Mr. Khalif was injured by an officer, it was Mr. Khalif who threw the first punch. Next, we will show you the other half of what happened outside of those prison walls. The plaintiff wants you to believe that this story started on May 29th, 2016, when Mr. Khalif reported for prison. But today, Dr. Vi Ran, Mr. Khalif's psychologist, will explain that this story started all the way back in 2007, when Mr. Khalif was repeatedly beat by a parent, when Mr. Khalif was locked in a closet, when Mr. Khalif was 8 years old. Dr. Ran will testify that it was the stress, this trauma, this childhood abuse that is far more likely to have caused Mr. Khalif's PTSD than anything that happened in prison. Dr. Ran's testimony will leave the plaintiff unable to prove that Mr. Khalif's suicide resulted from any action or inaction by the defendants. Members of the jury, I want to be clear. Today, you will hear testimony about the prison and about the guards that, well, simply isn't flattering. Instances where the guards were too slow to intervene, instances where the prison was too slow to recognize the extent of Mr. Khalif's pre-existing mental health problem. And that half of the story is true, but the other half of the story will show that whatever mistakes the prison made, the guards made, weren't the real causes of Mr. Khalif's issues. The evidence will show the prison did not cause Mr. Khalif's parent to abuse him. The prison did not cause Mr. Khalif to punch another inmate, punch another guard. The prison did not cause Mr. Khalif to develop PTSD. And the prison did not cause Mr. Khalif to take his own life. And at the end of this trial, once you've heard the other half of the story, once you've heard the full story, we ask that you find the defendants not liable.
Thank you. All right, that concludes the opening statements, and now we'll proceed with the testimony. Is the plaintiff ready to call your first witness?
Yes, Your Honor. The plaintiff calls Harry Khalif to the stand.
All right, Mr. Khalif? You may take a seat.
May I proceed, Your Honor?
You may.
Would you please introduce yourself to the jury?
Hello. My name is Harold Khalif.
Well, what do you do for a living, Mr. Khalif?
I'm usually working a couple jobs. Whatever I can do to support the family. I lost my wife to cancer 5 years ago. Ever since, one income wasn't enough to feed all the kids. So right now I'm a cashier at Costco and I drive for Uber.
You said that you and your wife had kids. How many did you have?
We couldn't get pregnant, so we adopted 4 amazing kids. Merrick was our youngest.
When was Merrick born?
October 2nd, 1998. His 19th birthday would have been next month.
When did your son pass away?
February 17th. This year.
Mr. Khalif, I know this must be hard for you. If you need a break, just don't hesitate to let me know, okay?
Thank you.
Before Merrick went to prison, what was Merrick like?
Merrick, he was happy. From the moment we brought him home. It just made you want to be around him. He had this amazing smile.
Did Merrick ever get in trouble with the law?
Growing up, no. But 2 years ago, Merrick got arrested for giving some weed to another kid at school. Because he had been caught before, the judge gave him 6 months in prison.
I need to talk about how Merrick did while he was in prison. Were you able to stay in touch while he was there?
Yes. I visited him as often as I could. Usually twice a month. I wish we had more time.
When Merrick first arrived at prison, how did he seem to be doing?
You know, at first he was fine. He sounded good. He sounded like himself. And when I visited, he was still smiling.
You said that Merrick was all right at first. When did things start to change?
July. The first time they put Merrick in solitary.
How do you know that the
Objection,
prison
Your Honor,
place...
calls for speculation.
Counsel, your response?
Yes, Your Honor. I asked this witness to testify as to how he knows what happened to his son while he was in prison. And I'm about to ask the witness how he knows that his son was placed in solitary confinement. There's no speculation here.
All right, I'm going to overrule the objection. Thank you.
Yes, Your Honor.
Mr. Khalif, how do you know that the prison placed Merrick in solitary confinement?
The prison officials told me. The warden and the head of the psychiatric unit.
Were you able to visit your son after he was released from solitary confinement?
Yes. I saw him as soon as he was out.
How did he sound?
Not good. He said, "Dad, I feel like I'm still in there. I feel like I'm still locked in that box."
Objection, Your Honor. This testimony is hearsay.
Your response, counsel?
Your Honor, we're not offering this for the truth of the matter asserted, but rather to show the witness the Merrick Khalif's state of mind.
I'm going to overrule the objection. Thank you.
Did you get a chance to finish your answer?
He said he kept reliving it all, and that he felt alone. And he started crying. I started crying.
You said that that was the first time the prison placed Merrick in solitary confinement. When was the second time?
October to December. They put my son in that hole for 56 days.
How do you know that the prison placed Merrick in solitary confinement for more than 2 months?
The warden told me. I called him every week to ask why Merrick was still in solitary. The warden put me on hold. Then he'd come back on and say Merrick was a danger to other inmates.
Mr. Cleef, when was the last time you saw your son while he was in prison?
December 2nd. He'd been in there for 56 days straight.
That last time you saw your son, how did he sound?
Hopeless.
Objection, Your Honor. Calls for speculation.
Your response, counsel?
Your Honor, this is a proper lay witness opinion. I've established that this is the witness's father. He's testifying to what he observed with his 5 senses.
All right, I'm going to overrule the objection. Thank you.
Yes, Your Honor.
Did you get a chance to finish your answer?
He sounded hopeless.
What do you mean by that?
He said, I can't do this anymore. It all needs to end.
What about when Merrick left prison? Did you notice a change in his demeanor?
No, he wouldn't really talk about it. I just heard him crying and screaming. I'd go in and say that I loved him, that I was there for him. When he looked back at me, his eyes, they looked empty. Once they put him in solitary, I never saw him smile again.
Thank you, Mr. Khalif. Your Honor, I have no further questions.
All right. Is the defendant ready for cross?
Yes, Your Honor.
All right, you may proceed.
Mr. Khalif, your son was sentenced to prison in 2016, correct?
Yes, he was.
This was because he committed a crime.
He gave some pot to a kid at school.
And that was a 6-month sentence, is that correct?
Originally.
Now, Mr. Khalif, is that a yes? He was sentenced to prison for 6 months?
At that time, he was.
All right, I want to make sure we understand what you were and were not able to see. Now, you visited Merrick many times while he was in prison, correct?
Like I said, whenever I could.
You saw that he had bruises?
He did.
You saw that he had some other injuries too.
He told me that the guards had been beating him, and he told me awful stories.
Mr. Khalif, that's not what I was asking. So you saw the bruises and you saw other injuries, is that correct?
Yes.
But Mr. Khalif, you never saw the altercations that started those injuries.
I only know what Merrick told me.
Is that a no to my question?
I'm sorry, could you repeat the question?
You never saw the altercations that started. You never saw the altercations that caused those injuries?
Oh, I wasn't there.
You never saw who started those altercations, is that correct?
I know who started them.
Mr. Khalif, did you ever see for yourself who started those altercations?
No.
So let me understand, the only knowledge you have of your son's altercations, your son's injuries, is from what your son told you.
That's right.
All right, let's talk about the mental health programs that POWA provided. You know that while your son was in prison, he received psychiatric treatment?
I know that he met with a psychiatrist.
And that's Dr. Singh, right?
Yes.
You've spoken with Dr. Singh multiple times?
Over the phone.
But Mr. Khalif, you were never physically present for Merrick's meetings with Dr. Singh, correct?
No, I wasn't.
And if Merrick, say, left something out, you wouldn't know.
I'm sorry, why would Merrick leave something out?
Mr. Khalif, you weren't present for his meetings, and so if Merrick were to left something out, you wouldn't have known. Is that correct?
I don't know.
If Merrick left something about his childhood out, you wouldn't know either, correct?
No, I wouldn't.
Now, Mr. Khalif was released from prison on December 24th, 2016.
Yes.
And after that, POWA provided him with a mental reentry program, correct?
I encouraged him to go, but he wasn't very enthusiastic.
So the prison did provide him with a mental reentry program?
Yeah, they did.
And this was with Dr. Rand, correct?
Yes,
You've spoken with Dr. Rand on multiple occasions, right?
I have.
Dr. Rand told you that Mr. Khalif's condition was getting worse.
I didn't need a psychologist to tell me that, but he said that.
Dr. Rand told you something had to be done.
Yes.
Dr. Rand also told you, Mr. Khalif, that if she was going to get anything done with Mr. Khalif, he had to show up at all the meetings with her. Is that correct?
I think he said it would be better if he showed up, but I couldn't always make Merrick go.
So, Mr. Khalif, you understood how important all of these meetings were, correct?
They were important.
But Mr. Khalif never showed up at all of those meetings, did he?
He didn't.
Nothing further, Your Honor.
All right, thank you. Any redirect?
None needed, Your Honor. May the witness be excused?
Yes, he may be excused. Thank you, Mr. Khalif. All right, is the plaintiff ready to call your next witness?
Yes, Your Honor. Plaintiff calls Franklin. Your Honor, before beginning the exam, may I set up a Jamal survey?
Yes, you may.
Thank you. Your Honor, is this all right?
That's fine, and the defendant's counsel, you feel free to step to the side so you can see the demonstrative during the examination.
Yes, Your Honor.
Would Your Honor mind asking the jury if they can clearly see the demonstrative?
Can the jury see clearly? Okay, good.
May I proceed?
Yes, you may.
Good morning. Please introduce yourself to the jury.
Hello, my name is Ferenc Laszlo Lin, but in America they call me Frank.
Where do you live?
Recently I get out of prison. Until I can get passport, I have to stay in United States.
Why were you in prison?
Very simple. I hire a bad lawyer.
Sir, I'm asking you what crimes you were convicted of?
Oh, trespass, heroin.
Well, I want to turn your attention to the events of this case. I want to do that by showing you a couple of photographs. Your Honor, I'm showing opposing counsel exhibits 9, 20, 33, and 35.
All right,
May I approach the witness with the same?
you may.
And would Your Honor like a courtesy copy?
Sure, if you have any.
May I approach the bench?
Yes, you may.
Thank you.
All right, thank you.
Mr. Lin, can you tell us what the first exhibit, exhibit 9, depicts?
This is my best friend in prison, Merrick Khalif. He was like brother to me. May he rest in peace.
Your Honor, plaintiff offers exhibit 9 into evidence.
Any objection?
No, Your Honor.
All right, 9 is admitted.
Permission to reveal an enlargement to the jury, Your Honor?
Yes, you may.
Mr. Lin, how did you get to know Merrick while you were in prison?
I was cell 1B25. Merrick 1B26. He snore. I only want to put up with him. We become friend.
What was Merrick like when you first met him?
He was, how you say, lucky-go-happy guy. He was always talking about big dreams.
Did you get to know any other inmates while you were at the prison?
Yes, the big boss of local prison gang,
Who was that?
Patton Schreier. I call him Pitsy Molots. He think it mean very strong man. It really mean little baby piggy.
Well, let's take a look at that next exhibit, Mr. Lin. What does exhibit 20 depict?
This is Merrick after 12th July. I will never forget.
Your Honor, plaintiff offers exhibit 20 into evidence.
Any objection?
No, Your Honor.
All right, 20 is admitted.
Mr. Lin, can you tell us what happened on the 12th of July?
We are playing basketball. Prison gang come. Then they start yelling, punching, shoving. Merrick fall to the ground. And they start kicking. Again and again.
Mr. Lin, while these other inmates were punching and kicking Merrick, were there any prison guards nearby?
Yes. Officer Meg James.
Well, what did Officer James do?
She watched the whole thing.
How long did it take Officer James to respond?
3 minutes.
Was she doing anything during this time?
Finally, after 3 minutes, she come over and start clapping. Then she start kicking Merrick too.
Let's take a look at those next two exhibits. Exhibits 33 and 35, can you tell us what they depict?
This time, Merrick is beat by guard. 3 October.
Your Honor, plaintiff offers Exhibits 33 and 35 into evidence.
Any objection?
No objection, Your Honor.
All right, 33 and 35 are admitted.
Mr. Lynn, you said that this is when a guard hurt Merrick. Who was this guard?
Officer James.
Were you able to see what happened on October 3rd?
I see the whole thing.
Mr. Lynn, how did Merrick get this injury on his neck?
Officer James take out her baton. She push it into Merrick's neck. Until he say he cannot breathe.
How did Merrick get these injuries under his eyes?
Punching. Officer James punch. While Merrick is on the ground.
Mr. Lynn, did Merrick return back to his cell after each of these incidents?
No. They put him in solitary. The box.
What was Merrick like after his first time in solitary?
Not the same. No talk. No play b-ball. Never talk about big dreams.
What was Merrick like after his second time in solitary?
I no recognize him. He scream, cry. It broke my heart.
Mr. Lynn, did Merrick ever tell you anything about his time in solitary?
He say, I am scared to go back.
Thank you. Your Honor, I have no further questions.
All right, thank you. Defendant, are you ready for your cross?
Yes, Your Honor.
All right, you may proceed.
Your Honor, before I proceed, the defense asked that the plaintiff bring down their demonstrative for the cross-examination.
Yes, you may do that. Please do that.
Your Honor, may I proceed?
Yes, you may.
Good morning, Mr. Lynn.
Good morning.
I want to talk to you about your relationship with the plaintiff, Merrick Khalif. You entered the prison in May of 2016,
This is correct.
and Mr. Khalif arrived just 2 weeks later.
Yes.
And during the 2 weeks before Mr. Khalif entered prison, you mostly kept to yourself?
Yes, I lay low, like snake in grass.
You didn't talk to any other inmates?
No,
Didn't join basketball games?
I did not.
You didn't really talk to, you didn't really play any card games with other inmates as well, did you?
No, I watch.
But you started talking to Mr. Khalif almost immediately after he entered the prison, correct?
Yes, I did.
You and Mr. Khalif became friends?
We become best friends.
You two stayed in the same cell block, correct?
Yes, right next to each other.
You two, in your own words, became really close?
This is correct.
You consider Mr. Khalif like your brother?
He was family, yes.
Now, I'd like to talk to you about the altercation that happened on July 12th. You were there, right?
I was there, yes.
And a fight occurred.
Yes.
You were standing next to Merrick,
I was with him, yes.
and some other inmates walked over to you two,
The gang shows up.
and one of them shoved you.
Yes.
At that point, the inmate hadn't shoved Merrick, had he?
Not at that point, no.
At that point, the inmate hadn't pushed Merrick.
This is correct.
At that point, the inmate hadn't punched Merrick.
No, he didn't punch him. No.
At that point, the inmate hadn't even touched Merrick, correct?
No, he hadn't.
It was only after Merrick shoved the inmate that the inmate punched Merrick back.
Yes.
Now, I'd like to talk to you about the altercation that happened on October 3rd. On that day, there was an incident in Mr. Cleef's cell.
Do you mean the one with Officer James?
Yes, Mr. Lin.
Yes, I see this.
And you had a clear view of what happened?
I did. Yes.
And you heard Officer James say he was searching for drugs in Merrick's cell, correct?
I hear him yell.
And when he was searching for the drugs and he didn't find anything, he saw Merrick Cleef put his hand over to his pocket about an inch above his knee.
Objection, Your Honor. Speculation as phrased.
Your response?
Your Honor, the witness testified how he was able to see the incident, so he should be able to testify whether or not he could see the inmate, if he could see his friend Merrick Cleef put his hand over his pocket at that time.
May be heard, Your Honor.
Yes, you may.
Opposing counsel's question as phrased was he saw, as in Officer James, saw Merrick move his hand over his pocket. Your Honor, as phrased, this is speculative. The witness can't tell us what another person saw.
All right, I'm going to sustain the objection, but you may rephrase.
I'll rephrase my question. Mr. Lin, did you see Mr. Cleef move his hand over to his pocket?
Yes. I see him put hand in pocket.
And at that point, Officer James tried to get the object, correct?
Objection, Your Honor. Speculation as phrased.
Your Honor, I'll rephrase my question.
All right, you may.
At that point, you saw Officer James reach for the object?
This is when I see him choke him.
I wasn't asking if he was choking him, Mr. Lin. I was asking if you saw Officer James try to reach for the object in Merrick Cleef's pants.
This is what happened eventually.
Right, but before that, before you mentioned the choking, he did reach for Mr. Cleef's pocket, correct?
No, he pushed him up against the wall first.
And after that, he reached for the object?
After that, he started choking.
Did you see Officer James reach for the object in Merrick Cleef's pants?
Eventually, yes.
And Merrick resisted this Officer James, correct?
Of course, he was choking.
Merrick resisted the search for the object in his pants?
Yes, he was struggling against the wall.
And he started kicking, correct?
Yes, he did.
He started kicking the officer?
He started kicking at him, yes.
And after that, Officer James pulled out his baton and pinned it to his throat, correct?
He did, yes.
And after that, when Officer James left, you saw Merrick Cleef grab Officer James' head by the neck and slam it against the bars?
This is correct. We all see this.
Thank you, Your Honor. No further questions.
All right, any redirect?
Yes, Your Honor.
All right, you may proceed.
May I proceed?
Yes, you may.
Mr. Lin, on July 12th, what happened before Merrick shoved that other inmate?
This is when the prison gang come up, start yelling at us, cursing at us, shoving us.
And on October 3rd, was Officer James doing anything before Merrick had grabbed him? Excuse me, her?
Yes. She had punched him while he was on the ground.
Thank you. Your Honor, I have no further questions. May I retrieve the exhibits from the witness and tender them to the bench?
Well, let me see if we have any recross.
Of course, Your Honor.
No recross, Your Honor.
All right. Yes, you may retrieve the exhibits and the witness may step down.
Thank you, Mr. Lin.
Did you want my courtesy copies as well?
Your Honor can keep it if you'd like.
Okay. All right, is the plaintiff ready to proceed with your next witness?
Yes, Your Honor. Plaintiff calls Dr. Haka Singh.
Dr. Singh?
Your Honor, before I proceed with this examination, may I set up a demonstrative aid?
Yes, you may.
Good morning, Dr. Singh. Please introduce yourself to the jury.
My name is Dr. Haka Singh. I'm a psychiatrist.
How are you involved in this case?
Merrick was my patient during his time in prison. When he committed suicide after leaving my care, I was asked to determine why.
Before we talk about your conclusions, I want the jury to get a sense of your credentials. Can you summarize your experience as a psychiatrist?
Certainly. As a board-certified psychiatrist, I've been treating patients for the past 15 years. In hospitals, psychiatric wards, most recently in prisons. From 2008 up until earlier this year, I was the chief psychiatrist for Prisons of Western America, or POWA.
Let's talk about your conclusions. Informing them, what information did you have?
I had access to Merrick's medical and mental health records, the notes from the doctor who treated him after his release, the notes from my 5 formal meetings with him, and the results of his psychological testing.
Did you use reliable principles and methods when forming your conclusions?
Certainly.
Dr. Singh, I want to be upfront with the jury. Earlier you said that you used to work for the defendant, but you don't any longer. Why did you stop working for them?
I was fired for speaking out against private prisons. I'm currently in a lawsuit against POWA.
How many of your conclusions were drawn after you were fired by the defendant?
None of them. Every conclusion I drew, I reached while I was still working for POWA.
And did you form those conclusions to a reasonable degree of medical certainty?
Of course.
Your Honor, we tendered Dr. Singh as an expert in psychiatry with a specialization in the psychiatric care of prison inmates.
All right, any objection?
No, Your Honor.
All right, do you need a voir dire?
No, Your Honor.
All right, so the doctor is admitted as an expert in psychiatry.
Doctor, would the use of a demonstrative aid help you explain your conclusions to the jury?
It would. I brought a timeline for that purpose.
Your Honor, may Dr. Singh approach our demonstrative?
Yes, she may.
Your Honor, may we move in order to see the demonstrative properly?
Yes, you may.
Doctor, what are we looking at?
This is a timeline of Merrick's time in prison, beginning on May 29th, ending on December 24th. I constructed it using the statements made by the warden as well as my own first-hand knowledge.
What do the black bars represent?
These black bars represent the times Merrick spent in solitary confinement. 28 consecutive days in July and August. 62 consecutive days in 62 consecutive days in October, November, and December.
What is solitary confinement?
It's isolation. A prisoner is removed from the general population, has almost zero human contact. They spend over 22 hours a day in a tiny cell, only required to be 8 by 10 feet.
When did you first meet Merrick?
October 17th. I'm sorry, September. shortly after his first solitary confinement.
What were his symptoms at that point?
Insomnia, flashbacks, nightmares. Merrick reported daily flashbacks of his time in prison, including the feelings of loneliness and hopelessness that went with it. He told me that even though he was no longer in solitary, he still felt, quote, trapped in that box.
Were you able to make a diagnosis?
I was. That was on October 17th. I issued the CAPS-5 test and diagnosed Merrick with depression and post-traumatic stress disorder, or PTSD.
Doctor, what is PTSD?
It's an intense, sometimes life-threatening anxiety disorder, where a patient keeps reliving a traumatic event from the past, especially if they experience something similar. For example, a gunshot victim might become fearful or panicked every time they hear a loud bang, whether that's a gunshot on TV or a car backfiring outside.
What was the traumatic event that caused Merrick's PTSD?
Solitary confinement. That was what immediately precipitated his symptoms. That was the trauma he kept reliving.
What kind of trauma does solitary confinement cause?
Studies show patients put in solitary confinement often experience hallucinations, depression, feelings of hopelessness, brain dysfunction, and suicidal ideations.
Well, doctor, when someone develops PTSD as a result of being placed in solitary confinement, does additional time in solitary help cure their PTSD?
No. In fact, it's just the opposite. Because Merrick's PTSD was caused by the solitary confinement, placing him back in that situation was the worst possible thing we could do.
So, what did you do?
I went to the warden. I gave her a transcript of Merrick's interview. I told her about Merrick's PTSD caused by the solitary confinement and requested that he be removed from solitary immediately.
Thank you, doctor. You may retake your seat. Your Honor, I'm approaching opposing counsel with what has previously been marked as Exhibit 44.
All right.
They're both the same thing.
Okay, this is the. Okay.
Would Your Honor like a courtesy copy?
Yes, I'll take a courtesy.
May I approach?
Yes, you may.
And may I approach the witness with the same?
You may. Thank you.
Doctor, do you recognize this exhibit?
Yes, this is the transcript of the interview of Merrick Khalif.
Is it a fair and accurate copy?
It is.
Your Honor, we offer Exhibit 44 into evidence.
All right, any objection to 44?
No, Your Honor.
All right, 44 is admitted.
Doctor, I want to focus on one statement made by Merrick in this interview. Can you read what he said about solitary confinement on page 9?
I can. Each night that I spend in solitary feels like a lifetime. At times, this whole thing feels like a dream that I haven't woken up from. And I question what's real and what's in my head. I sometimes think that death couldn't possibly be worse than this life. At least I wouldn't be in pain all the time.
When you gave that to the warden, and you recommended that Merrick be moved out of solitary to a treatment ward, what did the warden say?
She said no.
Did she give a reason?
She said it was too expensive.
Objection, Your Honor, hearsay.
Your response, counsel.
Your Honor, this is an admission by party opponent.
Your Honor,
Counsel?
this statement's still being offered for the truth of the matter.
I'm going to sustain the objection.
Doctor, how much longer did Merrick remain in solitary confinement?
52 days.
Why did you determine that solitary confinement was the reason that Merrick committed suicide?
On February 17th, Merrick told a psychologist why he was feeling hopeless. He said he couldn't escape the solitary confinement. He kept repeating that phrase over and over, "I can't escape." 2 hours later, he took his own life.
Thank you. Your Honor, I have no further questions. May I retrieve the exhibit?
Yes, well, let's just keep it in case we need it for cross.
Yes, Your
All
Honor.
right, thank you. Are you ready for cross-examination?
Yes, Your Honor.
All right, thank you.
Before we proceed, we ask that the demonstrative be taken down.
Yes, if you could please take down the demonstrative, counsel. Counsel, can you take down the demonstrative?
Yes, Your Honor.
All right, thank you.
Thank you. Your Honor, may I proceed?
Yes, you may.
Good morning, Dr. Singh.
Good morning.
Now, as an expert witness, you would agree that it's important to be impartial.
Of course.
With that in mind, you mentioned that you used to work for prisons of Western America,
I did, up until earlier this year.
specifically February 2017.
That's right.
And of course, you remember making an affidavit for this case.
I did, yes.
You prepared that affidavit in June 2017, correct?
I did.
In other words, by the time you had completed your affidavit, you had already been fired by one of the defendants.
That's true, counsel. However, my conclusions were formed before I was fired.
Thank you, Dr. Singh, but directing back to my question, when you finished your affidavit, you had already been fired by one of the defendants, correct?
Like I said, yes.
Now, Dr. Singh, you would also agree that it's important for any medical practitioner to have access to all relevant information about their patient, correct?
Of course, in all cases.
In this case, you treated Merrick Khalif.
I did.
You spoke to his father over the phone.
I did, yes.
You spoke to him in person.
His father, counsel?
You spoke to Merrick Khalif in person.
I did speak to Merrick Khalif in person on 5 different dates.
You administered psychological tests to evaluate his mental state.
That's right, the CAPS-5 diagnosis test.
Now, Dr. Singh, for the benefit of the court, can you tell us what CAPS-5 stands for?
The CAPS-5 stands for a clinician-administered PTSD scale.
For the DSM-5, correct?
That's correct.
Thank you. Now, after Merrick was released from prison, you never spoke to his father over the phone again.
I didn't.
After Merrick was released from prison, you never met with Merrick Khalif in person again.
That's correct. He was transferred to a rehabilitation center where he was treated by Dr. Viran.
But nonetheless, you never met with him again.
No, I didn't.
You never administered any other psychological tests of Merrick after he had been released.
That's correct. Once again, he was transferred to a rehabilitation center.
So, Dr. Singh, by the time that Merrick had committed suicide, you hadn't seen him in 2 months.
That's right.
And as you previously stated, Dr. Rand did meet with Merrick after he was released.
Yes, Dr. Viran met with Merrick on 2 occasions after he was released.
And of course, you reviewed Dr. Rand's report.
Of course I did.
And you learned that Merrick Khalif shared information with Dr. Rand that he had never shared with you.
He shared the childhood abuse with Dr. Viran, but additionally he did share that with me.
But he never went into detail with it with you, correct?
He did tell me he was locked in a closet by his uncles at age 6. Besides that, he didn't go into further detail.
Now, Dr. Singh, I want to talk about Merrick's mental state. You met with him in September 2016, correct?
I did.
And during that meeting, Merrick never said that he was contemplating suicide, did he?
That's correct. On our initial evaluation, he didn't mention any suicidal ideations.
And again, you met with him in October 2016, correct?
That's right, October 17th.
And once again, Merrick never said that he was contemplating suicide, did he?
That's correct.
You met with him 3 more times in December.
I did.
Specifically, I'm referring to December 5th, 2016. You met with him that day, correct?
That's correct.
And that day, among other things, Merrick said that he just wanted to make it stop.
That's true. He did.
And you considered this a suicidal thought.
I did, yes.
However, this was the first time that Merrick had ever expressed a suicidal thought to you, correct?
That's correct. December 5th was the first time he explicitly mentioned a suicidal ideation.
And of course, you went straight to the warden.
Of course.
You recommended that Merrick be taken out of solitary confinement.
I did.
You recommended that Merrick meet with a counselor daily.
I did. That's what needed to be done.
You recommended that Merrick meet with you twice more before his release, correct?
That's right.
And at the time that you spoke to the warden, he agreed to all 3 of those recommendations, correct?
That's correct. After meeting with him on December 5th, he did agree finally to go with my plan.
Thank you, Your Honor. No further questions at this time.
All right, any redirect?
Yes, Your Honor.
All right, you may proceed.
Dr. Singh, why didn't the warden listen to your recommendations?
Well, counsel, he explained to me that it would be too much work to transfer him.
Objection, Your Honor. Outside the scope of my cross.
Your
May I be
response, counsel?
Your Honor, this witness asked about the warden's reactions to this witness's recommendations.
Your Honor, may I respond?
Yes.
I asked about the second incident in which the warden did agree to the recommendations of Dr. Singh. I wasn't referring to the first incident in which the warden did hesitate with Dr. Singh's recommendations.
I'm going to find it within the larger scope of the cross, so I'm going to overrule the objection. Thank you.
Did you finish your answer?
No. Basically, he told me that it would be too much work to move him out of solitary confinement. He said that money was an issue.
Objection, Your Honor. Hearsay.
Your Honor, may I be heard?
Yes, you may.
Your Honor, we're representing the estate of Merrick Khalif in this case, and our party opponent is Prisons of Western America. Warden Fast is an agent of that prison. This statement is an admission by party opponent.
Once again, Your Honor, it's offered for the truth of the matter.
I'm going to overrule the objection.
No further questions, Your Honor. May this witness be excused?
Yes, she may. Oh, well, let me see if there's any recross.
No, Your Honor.
All right. Dr. Singh may be excused. Thank you.
Thank
and
you.
you may retrieve your exhibits at this time.
Yes, Your Honor.
All right. Does the plaintiff have any further witnesses?
No, Your Honor, with that, the plaintiff rests.
All right. Thank you. Is the defense ready to proceed?
Yes, Your Honor. The defense calls Officer Meg James to the stand.
All right, Officer James.
Your Honor, may I proceed?
You may.
Good morning, officer. Please introduce yourself to the jury.
Morning. Meg James. That's James.
Where do you work?
I'm a correctional officer at Powell Imperion.
As a corrections officer, what are some of your responsibilities?
My main responsibilities is keeping the inmates in line. I do my job in there, so all of you can feel safe out here.
For how long have you been working at POWA?
About 9 years now.
All right, officer, I want to direct your attention to today's case. Are you familiar with a young man named Merrick Khalif?
Yes, inmate 24601. I'm familiar with him.
How do you know him?
He was an inmate in the same cell block I was working at while he was incarcerated.
And while you were in there, how long did you know Merrick Khalif?
From May of 2016 to December of that same year, about 6 months.
During those 6 months that you knew him, based on your observations, how would you describe Mr. Khalif's behavior as an inmate?
I discovered very quickly that he was a very violent inmate. Had a short fuse, if you will.
Oh, you say he was violent. I want to talk about that. On how many occasions did you witness him being violent while he was in prison?
2 specific times, ma'am.
All right, I want to talk about both of those times. When was the first time that you saw Mr. Khalif become violent?
That was on July 12th.
And where did this incident occur?
It was outside on the basketball court.
Where were you?
I was standing by the door that connects the basketball court to the prison.
Officer, from where you were standing, could you clearly see what happened on the other side of the court?
Yes, of course.
Can you describe what you saw?
Yes. Another inmate, Patton Schreier, and some of his friends had gone up to Merrick Khalif and Frank Lynn. There was yelling on both sides, and then Schreier shoved Merrick, but Merrick punched back.
Did you ever intervene?
Yes. The situation escalated to a point where it could not resolve itself, so I intervened.
Officer, did you ever make any kind of a report for this incident?
No, I saw no need.
Why not?
This kind of thing happens in prisons all the time. It's a prison after all, not a daycare. A little shove, a little punch. Very common.
You mentioned there was a second incident when Mr. Khalif was violent. When was that?
This was on October 3rd, ma'am.
Where did that incident occur?
In Merrick Khalif's cell.
And where were you?
I was in the cell with the inmate.
Officer, why were you in the cell with the inmate?
I was conducting a drug search from an anonymous tip I had received.
While you were conducting this search, did Mr. Khalif ever put up any resistance?
Yes. When I tried to retrieve what I believed was contraband in his pocket, he responded with hitting, yelling, and kicking.
Were you surprised by this reaction?
No. I had seen him be violent previously.
So at that point, what did you do, officer?
I did what any good correctional officer would do. I used my baton as protocol and detained the inmate as I retrieved the contraband.
Now, officer, just a few more questions. In that first incident that you saw Mr. Khalif become violent, who threw the first punch?
Merrick Khalif.
And in the second incident that you saw Mr. Khalif become violent, who threw the first punch?
Again, Merrick Khalif, ma'am.
Nothing further at this time, Your Honor.
All right. Any cross-examination?
Cross-examination, Your Honor?
Yes.
May I proceed?
Yes, you may.
I want to talk about an incident that you mentioned on direct examination. You talked about an incident that occurred on July 12th, 2016, right?
Yes.
On this day, you witnessed a fight break out in the prison yard, didn't you?
That is correct.
It was a fight between Patton Schreier and Merrick Khalif?
Yes.
Now, in this incident, you saw Patton Schreier shove Merrick Khalif, right?
Just a little shove, yes.
And the Merrick Khalif responded by hitting him?
Yes.
And after that, Patton Schreier shoved Merrick Khalif to the ground, right?
I believe so, yes.
Started kicking him?
Yes.
Started stomping on him.
If you want to use that word, yes.
After this occurred, isn't it true that it took you 60 seconds to decide to intervene?
No. I noticed that the situation was escalating and I began to get concerned. But after a minute is when I walked up to them, yes.
Ma'am, so it's your testimony it did not take you 60 seconds to decide to intervene?
No, I said it did take me a minute, but before that minute, I was thinking that it would escalate.
Ma'am, I wasn't asking what you were thinking before then. I was asking you when you decided to intervene. And that was 60 seconds after that fight began, wasn't it?
Yes, 1 minute.
Isn't it true that you said that was fun to watch while it lasted?
In my line of work, anything could be entertainment.
Ma'am, that's a yes to my question. That fight was fun to watch while it lasted?
Yes, sir, I said that.
No further questions, Your Honor.
All right. Any redirect?
Yes, Your Honor.
All right. You may proceed.
Officer, when you saw the incident break out on the prison basketball yard, why didn't you immediately take action?
I couldn't. If I took action too early, it might cause a riot.
Nothing further at this time, Your Honor.
All right. Any recross?
No recross, Your Honor.
All right. Ms. James, you may step down. Thank you. All right. Is the defense ready to call your next witness?
Yes, Your Honor. The defense calls Patton Schreier to the stand.
Mr. Schreier?
Your Honor, may I proceed?
You may.
Good morning, Mr. Schreier. Please introduce yourself to the jury.
I'm Patton Schreier.
Can I call you Pat?
No.
Very well. Mr. Schreier, could you tell the court a little bit about yourself?
Yeah, I'm 18. I'm from West Empyrean, and I guess you could say I'm a big-time gangster. Well, at least in prison.
And how did you end up at prison?
It was stupid. I just got caught by some freaking cops after trying to take some drinks.
And that landed you in prison?
Well, and stealing a car, but that was it.
Mr. Schreier, how long have you been at Power?
For about a year now, but gotta say, wasn't a bad year.
And why's that?
I kinda like it there. I hear it's paradise compared to other prisons.
Paradise. Could you give an example as to how it's paradise, Mr. Schreier?
Well, I mean, I got a TV in my cell, there's a basketball court, weight room. Not bad for a prison, you know? Oh, and I got my guys there too.
Your guys?
Yeah, you know, my people. We got them on the inside and the outside. We call ourselves the Blue Shirts. People know us.
Now, Mr. Schreier, directing your attention to the case at hand, do you know a man named Merrick Khalif?
Yeah, I knew him.
How so?
His cell was right across from mine at Power, so I guess I saw him a lot.
At this moment, I'll be directing your attention to an incident that occurred on July 12th. This was the incident in the yard by the basketball court. Do you know what I'm referring to?
You sure do.
What happened?
Well, Khalif and I had words. I gave him a little shove, and he took a swing at me. I fought back.
Now, Mr. Schreier, to be clear, in this incident, who threw the first punch?
Yeah, Khalif did, for sure.
And how'd you respond?
Well, what do you think? I punched him back. Only took one left to bring him down, you know. And then I kicked him.
Now, in this July 12th incident, did any guards kick Mr. Khalif?
No.
Did any guards hit Mr. Khalif?
Nuh-uh.
Mr. Schreier, what role, if any, did the guards play in this fight?
Man, they just broke it up. Made me stop kicking Khalif.
Now, Mr. Schreier, I'll be directing your attention to an incident that occurred on October 3rd. This was the incident between Officer James and Mr. Khalif in his cell. Did you observe this incident?
Yeah, I did.
How did you observe this incident?
Well, I was in my cell at the time. Gives me a good straight look to Khalif's cell. Saw the whole thing go down.
And what happened?
Well, Officer James walks into Khalif's cell, starts looking around for drugs, looking under the bed, that sort of thing, and starts to pat Khalif down.
Mr. Schreier, why did he pat Khalif down?
Like why they always do. Making sure you ain't got any weapons, no drugs, you know?
And how did Mr. Khalif respond to this?
He got straight violent. He started throwing punches, he started kicking. I couldn't believe it. He was throwing punches at a god.
And after that happened, how did Officer James respond?
Well, she took out her baton, put it to Khalif's throat, till he stopped punching and kicking. I thought I was gonna get a lot worse than that.
Now, Mr. Schreier, in this October 3rd incident, who threw the first punch?
Yeah, Khalif did, no doubt. He started swinging before the god ever hit him.
Thank you, Your Honor. No further questions at this time.
All right, any cross?
Yes, Your Honor. Before I proceed with this examination, the plaintiff requests a time check.
Do we have a time?
The plaintiff has 22 minutes remaining.
Okay, thank you.
May I proceed?
You may.
Good morning, Mr. Schreier.
Hey.
I want to start by talking about the July 12th incident. Now, during that incident, you kicked Merrick 10 times, right?
Sounds about right, but I wish I had more.
So you'd agree that it took you 10 kicks before Officer James intervened?
Like I said, I don't know the exact amount, but 10 sounds about right.
After that incident, Officer James pulled you off of Merrick, right?
That's right, I was the one kicking him.
She didn't pull Merrick off of you.
No, Merrick was on the ground.
But Mr. Schreier, they didn't send you to solitary after that incident, right?
No.
They didn't send you to disciplinary confinement.
No.
But you didn't see Merrick back in his cell for a full month. Isn't that right?
Yeah, he was gone for a little bit.
That's a yes to my question. He
I
was
said
gone
yeah.
for a full month.
I said yeah.
Mr. Schreier, on direct examination, you said that POWA was like paradise. That was your experience? It was like paradise?
Yeah.
Well, I want to talk about Merrick's experience in POWA. Now, he was sent to solitary confinement after the July 12th incident. That's what you just said, right?
That's what they tell me.
And when he came back, he rarely left his cell.
Yeah, he was kind of lazy.
He seemed nervous.
How would I know?
Objection, Your Honor. Calls for speculation.
Your Honor, may I be heard?
Yes, you may.
The question was he seemed nervous. I'm not asking if he was nervous. I'm asking about this witness's perception.
All right, I'm going to overrule the objection. Thank
Yes,
you.
Your Honor.
Mr. Schreier, after the second time that Mr. Khalif went to solitary confinement, I want to talk about his reaction to that. Now, when he went to solitary confinement, you saw the guards pulling him away, right?
Pulling him away from what?
From his cell.
Oh yeah, that's right.
And he was screaming.
Uh-huh.
He was crying.
That's right.
He said, "Please don't put me back in the box."
That's what he said.
He said, "I can't handle the box."
Weak, yeah.
When he came back from that time in solitary confinement, he looked skinny.
Yeah, he was a lot skinnier.
He looked pale.
That's right, he did.
He had dark circles under his eyes.
Yeah, he did.
And you never saw him leave his cell.
After that, not really.
You never saw him leave his cell, right?
No.
Mr. Schreier, after Merrick came back from his second time in solitary confinement, you would hear him crying in his cell.
Yeah.
Is that a yes?
I said yeah.
No further questions, Your Honor.
All right. Any redirect?
None needed, Your Honor.
All right. Mr. Schreier, you may step down. All right, is the defense ready to call your next witness?
Yes, Your Honor. The defense calls Dr. Rand to stand.
All right, Dr. Rand. All right, you may proceed.
Good morning, Dr. N.
Good morning.
Please introduce yourself to the court.
Hello, my name is Dr. Vi Ran.
And what do you do for a living?
I'm a treating psychologist at Empyrion's mental health reentry program. As inmates leave prison and reenter society, I provide them with therapy and treatment.
Now, doctor, before we get into your findings, I want the jury to understand your credentials. Where did you go to school?
At the University of Empyrean, I earned my Bachelor's of Science in Psychology. At the University of Washington, I earned my doctorate in psychology. And at the University of Western Empyrean, I completed my postdoctoral fellowship.
And can you please describe your professional experiences?
I've been a treating psychologist for the past 17 years now. First at the state's Mental Health Services Department, then in private practice, and most recently with the reentry program I mentioned, where I've worked with parolees and released inmates for 6 years now.
Doctor, do you have any other professional experiences?
I do. Counsel, if you'd like, I have a CV that holds all my professional and educational backgrounds.
Your Honor, at this time I'm approaching opposing counsel with what has been marked as Exhibit 6. The judge. Would you like a copy as well?
Sure, I'll take a copy.
May I approach the witness with the same?
Yes, you may.
Now, doctor, do you recognize this?
I do.
What is it?
It's a copy of my CV.
And is it a true and accurate representation?
I believe so.
Your Honor, at this time, the defense would like to admit Exhibit 6 into evidence.
Any objection?
No objections, Your Honor.
All right, 6 is admitted.
Your Honor, permission to publish to the jury?
Yes, you may publish.
Now, doctor, are you certified or licensed as a mental health professional?
Actually, both. I am licensed by the state of Empyrean and certified by the American Board of Professional Psychology.
And in coming to your conclusion about the plaintiff, Merrick Khalif, did you have sufficient facts and data?
Yes, I performed our program's initial evaluation of Mr. Khalif. I met with him twice in clinical sessions, spoke with him 4 times over the phone, and I had access to all his medical files and the reports compiled by Dr. Singh, who treated Merrick while he was in prison.
And did you use reliable methods and principles?
Of course. I followed the protocol outlined in the DSM-5 and employed the treatment methods approved by the state.
And doctor, for the benefit of the court, can you please explain to us what DSM-5 is?
DSM-5 is the Diagnostic and Statistical Manual, Volume 5. It's the standard manual used by almost all psychologists.
And in coming to your conclusion, did you reach a reasonable degree of certainty in your field?
Yes, I reached all 3 of my conclusions to a reasonable degree of scientific certainty.
Your Honor, at this time, the defense offers Dr. Rand as an expert in the field of psychology.
Any response to that?
No objections, Your Honor.
All right. Dr. Rand is admitted as an expert in psychology.
Now, doctor, you mentioned you drew 3 conclusions based on Merrick Khalif. Can you please explain the first one?
Merrick Khalif suffered from post-traumatic stress disorder. This conclusion was reached by Dr. Singh, who treated Merrick while he was incarcerated. And I agree with this conclusion.
And what is PTSD?
PTSD is an anxiety disorder. It generally develops in response to a traumatic event, usually one that threatens death or serious injury.
And how do you know Mr. Khalif suffered from PTSD?
He showed the classic symptoms: disorientation, weight loss, slowed heart rate, nightmares, flashbacks to prison, and flashbacks to incidents that occurred outside of prison.
Now, doctor, what was that second conclusion that you mentioned?
In my professional opinion, I believe that Mr. Khalif's PTSD likely led to a suicide. On this point as well, I agree with the plaintiff's psychiatrist.
Now, doctor, what makes you think that Mr. Khalif's PTSD contributed to his suicide?
Well, first, it's not uncommon for PTSD to lead to suicide. Second, my records indicate that Mr. Khalif was no longer taking the medication specifically prescribed for his PTSD. This placed him further at risk. He also notified me that he was taking heroin at the time, which too put him at an elevated risk of making a spontaneous, self-harming decision.
Now, doctor, what was your third conclusion that you mentioned?
Although we can say with some confidence that Mr. Khalif had PTSD and that his PTSD had led to a suicide, it is impossible to determine what caused his PTSD. Sorry.
Is it possible that Mr. Khalif's time spent in prison caused his PTSD?
Absolutely. Mr. Khalif was beaten, humiliated, and put into solitary confinement during his time at POWA. I admit this as a possibility.
And doctor, why is this merely just a possibility?
Because I have found strong evidence that shows Mr. Khalif may have developed PTSD outside of his time from prison.
And what is the basis of this opinion?
It is based on what Mr. Khalif told me himself.
And doctor, what did Mr. Khalif tell you?
He told me that he was abused as a child.
What kind of abuse, doctor?
Physical abuse. One of his parents beat him. But more germane to our case today, that same parent locked him in a closet. He was only 8 years old.
And doctor, how long was Merrick Khalif locked in a closet as a child?
He told me it went on for 6 months.
So why is it important that Mr. Khalif was locked in a closet as a child over a 6-month period?
Because that's another form of solitary confinement. If solitary confinement at age 17 could cause PTSD, then so could solitary confinement at age 8.
Should the prison have considered this information before placing Mr. Khalif in solitary confinement?
In theory, yes, but Mr. Khalif did not disclose to prison officials of his past. In fact, he had barely mentioned it to Dr. Singh, who treated Merrick while he was in prison.
Objection, Your Honor. A lack of personal knowledge may be heard.
Yes, you may.
Your Honor, the witness just stated that Merrick Khalif had never given certain information to the officials of Powell Prison. We've heard no foundation as to how she could know this information.
All right, your response, counsel?
Yes, Your Honor. In the beginning of her testimony, she told the court how she reviewed over Dr. Singh's files and her reports as well. From looking at this, we can tell whether or not Dr. Ran has if Dr. Singh has gotten the same information as her by reading the reports that Dr. Singh has given her.
May be heard, Your Honor.
Well, I'm going to sustain the objection, but you may establish the foundation for this line of
Yes, Your
testimony.
Honor.
Thank you.
Move to strike, Your Honor.
I'm going to strike the previous testimony, but allow counsel to establish the foundation going forward.
Yes, Your Honor.
All right, thank you.
Doctor, in reading Dr. Singh's testimony, did you find out any indications that they knew about Merrick's past possible PTSD from solitary confinement as a child?
From the reports, I did see that Mr. Khalif talked briefly about the family history, but did not go in depth.
Now, should the prison consider this information that they briefly got before putting Mr. Khalif into solitary confinement?
In theory, yes.
Objection, Your Honor. Improper expert opinion. May be heard.
Yes, you may.
Your Honor, opposing counsel just asked this witness whether or not the Powell Prison is required to have an inmate looked at before solitary confinement. Your Honor, this witness is only an expert in psychology, not in prison rules, standards, or what should be done.
All right, counsel, your response?
Your Honor, the witness was testifying to Merrick's mental health and whether or not Merrick's mental health state would have been well suited in solitary confinement.
May be heard, Your Honor.
I'm gonna overrule the objection.
Yes, Your Honor.
Proceed. Thank you.
Please continue your answer. Would you like me to repeat the question?
Yes, please.
Should the prison have considered this information about Merrick's past solitary confinement before being placed into solitary confinement?
Yes, but Mr. Khalif did not disclose to prison officials of his past. In fact,
Objection, Your Honor. Again, lack of foundation and personal knowledge. Your Honor just ruled that this exact statement was not admissible in court.
Counsel?
Your Honor, we just laid the proper foundation when we asked if she read the reports made by Dr. Singh and whether or not it mentioned this information.
May I be heard, Your Honor?
Yes.
Again, Your Honor, the witness isn't specifically referencing to Dr. Singh's report. She's saying all Powell prison officials do not know this information. We've heard no foundation as to how this witness can know what every Powell prison official knows. She can certainly tell us what she found in Dr. Singh's reports concerning Dr. Singh's knowledge. She can't tell us what every prison official is aware of.
I'm going to sustain the objection, but you may rephrase.
Yes, Your Honor.
Move to strike the witness's answer, Your Honor?
Yes.
Dr. Singh, Dr. Ran, did you read Dr. Singh's reports based on Merrick Khalif's time in prison?
Yes, I reviewed all of his reports.
And after that, are you aware that the prison still put Mr. Khalif in solitary confinement?
Yes.
Now, putting together all of your conclusions, can you give your professional opinion on why on what caused Mr. Khalif's PTSD?
In my professional opinion, I believe that Mr. Khalif's... In my professional opinion, I believe that Mr. Khalif took his own life because he could no longer take the PTSD caused by solitary confinement. Counsel, I actually have a visual aid prepared to help the jury better understand my professional opinion on why Mr. Khalif took his own life. May I demonstrate it?
Your Honor, at this time, may my witness step down to demonstrate her visual aid?
Does the opposing counsel have any objection or response to that?
No objections at this time, Your Honor.
Okay, you may step down.
This represents the solitary confinement Merrick endured in 2007. This represents the first time Merrick was put into solitary confinement at Powell. and this represents the second time Merrick was put into solitary confinement at Powell. Now, it is impossible to determine what breath brought the balloon to critical pressure, causing it to pop. It could have been the first, second, or third breath. And similarly, in Merrick's case, it is impossible to determine what brought Merrick to take his own life. It could have been the 3 months of solitary confinement imposed by the prison in 2016, or the 6 months of solitary confinement imposed by his parent in 2007.
Thank you, Objection, Your Honor. More prejudicial than probative. Maybe hurt.
Yes.
Your Honor, the demonstrative that this expert just showed the jury is far more prejudicial than probative. Your Honor, and the way she demonstrated this demonstrative, she showed that with each breath, the mind of Merrick Khalif became more unable to cope with his disorder. Your Honor, and the way she demonstrated it, it appears as if the last breath is what caused this final moment to pop. What caused Merrick's disorder to increase to such a great moment that it caused him to take his life. Your Honor, the witness's own testimony is that this is not the case. The witness just told us that it's impossible to know which one actually caused his disorder to lead to suicide. Therefore, it's more prejudicial.
All right, counsel, your response?
Your Honor, this is not more prejudicial because before we brought up the demonstration, Dr. Rand said it was just a visual aid to help the jury better understand what she was talking about as her professional opinions. And as opposing counsel mentioned, Dr. Rand's testimony focuses on we don't know which one of these causes is the main purpose of Mr. Khalif's PTSD. And like she mentioned, each breath brought the balloon to critical pressure, and we're not sure which one caused it to be big enough to pop. She was not implying that it was the last one particularly that caused it to be big enough to pop.
Maybe heard, Your Honor?
I think I've heard enough. I'm going to overrule the objection.
Yes,
Thank
Your
you.
Honor.
Thank you, Your Honor. No further questions.
All right, cross-examination?
Yes, Your Honor. Before beginning, may I set up a demonstrative?
Yes, you may.
And may plaintiff request a time check?
Time check, please.
Yes, Your Honor. The plaintiff has 19 minutes and 15 seconds remaining.
Thank you. Your Honor, is this all right?
As long as the jury can see.
Would you mind asking, Your Honor?
Put the board up. Does the jury have any problem seeing that? Okay. All right.
May I proceed?
Yes, you may.
Good morning, Dr. Rand.
Good morning.
Now, on direct examination, you talked a lot about your conclusions in this case.
Yes.
Before we dive into them, I just want to make a clarification for the jury. Now, on direct examination, you said that your conclusion in this case was that the childhood trauma is what actually caused Merrick's PTSD. Those were your words, right?
Yes.
To be clear, in your expert report, you actually said that you don't actually know what the actual cause was, right, Doctor?
Yes, I believe that this was more likely than the other factors.
That's right, Doctor. You only found that it was a possibility.
Yes.
Now, you agree that Merrick Khalif took his life on February 17th, right?
That's correct.
And you agree that his suicide was caused by his post-traumatic stress disorder.
Yes, I stated that already in my direct examination.
Now, you gave us a couple different reasons as to what caused this post-traumatic stress disorder, right, Doctor?
That's correct.
Well, I want to jump right into those. Let's start with childhood trauma. Now, on direct, you told us that Merrick was abused as a child.
Yes, that's right.
And you believe that this abuse was what caused his post-traumatic stress disorder, right?
It may have well been.
Well, I want to clarify something for the jury. The year of the abuse, you received no report by anyone, including Merrick, that he expressed a single symptom of post-traumatic stress disorder, right?
That's right.
And the next year, you didn't get a single report that Merrick expressed a single symptom of post-traumatic stress disorder in that year?
I did not get a report.
In fact, Dr. Rand, you've received no reports from anyone, including Merrick, that in the entire time before he came to Powell Prison, he expressed a single symptom of post-traumatic stress disorder.
That's right.
Now, on direct examination, you briefly mentioned how medication could have affected Merrick's mental state.
Yes.
You said that his medication, stopping using his medication, could have made it worse, right?
Yes, I did say that.
To be clear, the medication Mr. Khalif was using to treat his post-traumatic stress disorder couldn't have been the initial cause, right, doctor?
Yes.
You also briefly mentioned the involvement of drugs, heroin, right?
That's correct.
That Merrick told you he'd been using heroin on the day he died.
Yes, he did say that to me.
But doctor, it's your professional opinion in this case that Merrick was using these drugs to cope with his disorder, right?
Yes, that's right, due to the lack of his medication.
That's right, doctor. So if Merrick's using his drugs to cope with a disorder, they couldn't have been the initial cause of that disorder, right?
That's correct.
Well, that brings us to the final possibility that you mentioned on direct. That's his prison trauma. Now, you admit that Merrick's time in solitary confinement was traumatic for him.
That's correct.
You know that in total he spent 90 days in solitary confinement, right?
I do know that.
That was a 8 by 10 square foot cell, right?
It was.
He had barely any human communication.
Yes.
His cell had no windows.
No, it did not.
He didn't get daily showers.
No.
He had little to no human contact.
That's right.
Now, psychologists have studied how prison solitary confinement can affect inmates, right, doctor?
Yes.
It can cause feelings of hopelessness,
That's right.
depression.
Yes, I've stated all of this before.
It causes panic,
Yes, it does.
hallucinations,
That's correct.
nightmares.
Yes.
In fact, doctor, you know that solitary confinement often leads to suicidal ideations in inmates, right?
Yes, as I said before, I have stated this.
Thank you, Your Honor. No further questions.
All right, any redirect?
Yes, Your Honor.
All right, and counsel, please take down your demonstrative.
Of course, Your Honor.
Thank you.
Dr. N, were you Merrick's treating psychiatrist while he was in prison?
No, I was not. I believe that was Dr. Singh.
And once he left prison and you treated him, why do you say that his childhood trauma is most likely the cause of his PTSD?
Well, because because he endured 6 months of solitary confinement, much more than 3 months.
Thank you, Your Honor. No further questions.
Any recross?
No recross, Your Honor.
All right, Dr. Rand, you may step down. And does the defense have any further witnesses?
No, Your Honor, the defense rests.
All right, well, this concludes the presentation of the evidence, and I promised everyone that we would get we'll take a break until noon to prepare for closing arguments, and at that time we'll proceed. All right, thank you. Okay, good. All right, are the parties ready for closing arguments?
Yes, Your Honor. Plaintiff is ready to proceed.
Is defendant ready to proceed?
Yes, Your Honor. We are ready to
Okay.
proceed.
We'll proceed with the plaintiff.
There are about 120 seats in this courtroom. But one of them is different. It's the witness table. You see, this is where people tell us what happened. This is where they tell their story. Now today you heard from 6 different people. A father, a friend, a psychiatrist, a prison guard, a gang leader, and another psychologist. The most important witness was the one who didn't take the stand. He was the one who couldn't. Instead, All we're left with are the words that Mayor Khalif spoke to his psychiatrist on October 17th. I quote, "Each night I spend in solitary feels like a lifetime. At times I think this whole thing feels like a dream that I haven't woken up from. I question what's real and what's in my head. I sometimes think that death couldn't possibly be worse than this. At least I wouldn't be in pain all the time." Members of the jury, those are Merrick's own words. You see, the warden of the prison didn't need a professional's recommendation to know that this young man was in trouble. He didn't need a formal diagnosis. All he needed was to be able to look at Merrick like a human being, not just a line item on his to-do list. Members of the jury, the warden didn't deny Merrick treatment that first time because Merrick didn't need it. He denied it because to them, he wasn't worth it. That's why Merrick is dead, members of the jury. Because to them, he was worthless. Now, as the plaintiff, I had the burden of proof. But I need to remind you that this wasn't a criminal trial. I didn't have to prove our case beyond a reasonable doubt, like you see on TV. All I had to do was tip the scale, show you that our facts are more likely true than not. I want to walk you through each of our claims chronologically and show you how we have met our burden. Let's take a look at the first claim on July 12th. That day, a prison gang assaults Mr. Khalif while the prison guard watches. Now, today you heard from multiple witnesses about what happened on July 12th. A prison gang approaches Mr. Khalif and his friend, Frank Lynn. They begin shouting and yelling. They begin shoving. Now, defense again and again has tried to tell you that Mr. Khalif threw the first punch, but members of the jury, I want you to remember the testimony of the multiple witnesses who testified today. Frank Lynn, Patton Schreier, Meg James all told you that Patton Schreier was the one who acted physically first. He shoved Merrick. Merrick responded. Today you heard that prison gang began to kick Merrick while he was lying on the ground again and again, more than 10 times. After that first kick, Officer James didn't intervene. After that second kick, Officer James didn't intervene. Members of the jury, after the 10th kick, Officer James didn't intervene. You heard that it took 3 minutes before Officer James decided to finally break up the fight. Now Officer James took the stand. She told you something different. She said, "Oh no, it only took me 60 seconds. Members of the jury, let's think about what can happen in a violent prison gang fight in 60 seconds. That was 15 seconds, members of the jury. By her own admission, Officer James watched Merrick get beaten by a prison gang for 4 times as long. That's deliberate indifference to Merrick's physical safety. That's count 3. But you see, as the judge will explain, it wasn't just Officer James. You see, before this trial began, both parties stipulated that Officer Meg James was acting within the scope of her employment. Basically, what that means is Officer James's actions are attributable to the prison that hired her. And when Officer James decided to not protect Merrick, when she knew he was in trouble, members of the jury, that's the very definition of deliberate indifference to physical safety. And that's count 2. Which brings us to the next incident you heard about today. And that was on October 3rd. But members of the jury, you heard that this time, Officer James wasn't watching other inmates beat Merrick. This time she was doing the beating. Now, it's true. Merrick shouldn't have resisted when Officer James was searching his cell and his person. And she had every right to use some force. But the judge will explain that Officer James is only allowed to use as much force as was necessary to restrain him. On direct examination, that's what Officer James told you. She said, "I was only trying to detain him. I only did as much as was necessary to detain him." Members of the jury, you saw the photographs. You heard witness testimony. Merrick was choked with a baton till he couldn't breathe. Merrick was beaten until he was bruised while he was lying on the ground. Now, once again, members of the jury, the defense has tried to give you another explanation. Merrick threw the first punch. Merrick was acting violent too. Members of the jury, again and again, all you heard today was that every action that Merrick took that was violent was in response to abuse by other inmates or by prison guards. Members of the jury, this is more than restraining an inmate. This is more than detaining an inmate. This is excessive force. And that's count 4. Which brings us to the worst wrongs done to Merrick. You see, worse than these physical injuries were psychological ones. Now today, Dr. Hakasing took the stand. And she told you that she diagnosed Merrick with post-traumatic stress disorder back in October. She told you that immediately she went to the warden and said, "Look, we got to get this kid out of solitary and into treatment immediately." Members of the jury, on redirect examination, the witness was asked, how did the warden respond? Do you remember what she told you? The warden said it was too much work. It cost too much money. It wasn't worth it. Members of the jury, that's deliberate indifference to medical health. But you see, it's so much more than that, because not only did the warden deny Merrick treatment, he sent Merrick back to the same solitary confinement that caused his post-traumatic stress disorder. You heard from both expert witnesses today, members of the jury. Merrick Khalif was put back in that cell for 62 more days. You heard about the effects of solitary on inmates. Opposing counsel's own expert witness agreed. Solitary confinement causes hopelessness, panic, hallucinations, nightmares, depression, suicidal ideations. Members of the jury, that's a testimony of their own expert witness. When the defendants decided to put Merrick back in that same cell for 62 days, that cell without a window, that cell without human contact, that cell that was separated from all people, the cell that caused his problems in the first place, members of the jury, that's deliberate indifference to mental health. That brings us to the final claim in this case. Wrongful death. You see, members of the jury, both parties have agreed that Merrick committed suicide. Both parties agree that it was caused by post-traumatic stress disorder. Today, the question was, what caused this disorder? Was it the trauma experienced in prison? Or was it the trauma he experienced back in 2004? Members of the jury, this is when you need to remember what their expert witness told you. You see, the first year of Merrick's abuse, there was not a single report of any symptoms of post-traumatic stress disorder. The year after the abuse, once again, no reports. When Merrick was 8, when Merrick was 9, when Merrick was 10, when Merrick was a teenager, members of the jury, year after year, Merrick didn't display a single sign of post-traumatic stress disorder. You heard, it wasn't until he stepped into prison that Merrick began to have those hallucinations, the depression, the suicidal ideations. Members of the jury, we know Merrick Khalif died. And we know that it was the defendant's actions that caused him to take his death, take his life. Should it be that much of a surprise, members of the jury? One defendant watched as Merrick was beaten by other prisoners. The other watched him wake up from nightmares and did nothing. I want you to think about the message that sends to a 17-year-old boy. When you're told that your life isn't worth protecting, that you're not worth treating, that you're not worth defending, that you're not worth saving, members of the jury, is it any wonder that Merrick decided his life wasn't worth living? Now I expect the defense to come up here and tell you that we're only telling you half of the story. That they're going to get up here and tell you what really happened. Members of the jury, here's the whole story. Merrick was hurt as a child. He had a traumatic life, a tragic one. But it wasn't until he came to the POWA prison that he got post-traumatic stress disorder. It wasn't until he went to the prison, the defendant's prison, that he became suicidal. It wasn't until he came to the prison that he was beaten, that he was abused, that he was locked in solitary confinement. Members of the jury, it wasn't until after he went to the prison that Merrick took his life. I ask you to find the defendants liable.
Thank you. All right, is the defense ready for closing argument?
Yes, Your Honor, but however, before I proceed, may I ask the demonstratives to be taken down?
Yes, please take the demonstrative down. Thank you. All right, you may proceed.
In their opening statement today, the plaintiff told you that Merrick Khalif was injured in multiple prison fights. But what they didn't tell you is that Mr. Khalif actually helped start those fights. That he threw the first punch. The plaintiff told you that Merrick Khalif has PTSD because he was locked in a confined space for a long period of time. But what they didn't mention is that that confined space was actually a closet in his house when he was 8 years old. The plaintiff argued that Merrick Khalif faced tough prison conditions. But the plaintiff didn't tell you that POWA provided Mr. Khalif with a psychologist. They didn't tell you that POWA provided Mr. Khalif with a psychiatrist. Today, the plaintiff tried to tell you only one half of the story. But when the evidence reveals the other half of the story, it becomes quite clear that Paua is not responsible for what happened to Mr. Khalif. Now, as defense, we had no burden of proof. We didn't have to prove a single thing. That's because that burden rested solely on the plaintiff. They had to prove every element of all 5 of their counts. One element that was common to all 5 of their counts is causation. You see, it wasn't enough for them to prove that Meg James made mistakes. It simply wasn't enough for them to prove that Paua made mistakes. No, members of the jury, they had to prove that it was these very mistakes that caused Mr. Khalif's injuries. I'll be more specific. Let's start with the claims against Officer Meg James. Now, the plaintiff argues that on July 12th, Officer James is responsible for the injuries suffered by Mr. Khalif. This is the incident that took place in the yard, where Mr. Khalif was punched and kicked. But let's think about what they're saying. The plaintiff argues that it wasn't Merrick Khalif's fault, even though the witnesses agree that he threw the first punch. The plaintiff argues it wasn't Patton Schreier's fault, even though he was the one punching and kicking. No, the plaintiff argues that it was the guard's fault, because he didn't intervene quickly enough. But today we heard conflicting accounts of how quickly she intervened, and the plaintiff's only eyewitness is Frank Lynn. Who is Frank Lynn? A convicted criminal. Also, Mr. Khalif's close friend. This brings me to the next claims against Officer Meg James. The plaintiff argues that Officer James used excessive force against Mr. Khalif in the incident in his cell on October 3rd. Yes, it's true, Officer James hurt Merrick Khalif that day. But the witnesses agree that Merrick Khalif kicked Officer James before Officer James ever hit Merrick Khalif. And the witnesses also agree that Merrick Khalif punched Officer Meg James before Officer Meg James ever struck Merrick Khalif. Members of the jury, we're not saying that Officer James is a model prison guard. But when you're an inmate, you don't get to punch the guards. You don't get to kick the guards. But if you decide to, you're going to get hurt. Officer James used force to subdue a violent inmate. There is no evidence whatsoever that shows that force was excessive. This brings me to the claims against the prison. The plaintiff argues that Paua acted with deliberate indifference towards Mr. Khalif's physical safety. But that's not true. The very first time Mr. Khalif was injured, he was placed in protective custody. And when he was released from protective custody, there's no evidence showing he was ever touched by another inmate. This brings me to the plaintiff's final claims. Now, the plaintiff claims that Paua is responsible and acted with deliberate indifference towards Merrick Khalif's mental health. That this deliberate indifference caused Mr. Khalif to develop PTSD. And that this PTSD ultimately led to Merrick Khalif's suicide. Members of the jury, this is where it is so important to remember the other half of the story. Merrick Khalif didn't develop PTSD when he got to prison. He didn't develop PTSD with solitary confinement in 2016. No, he developed it in 2007, when his own uncles beat him and placed him in a locked closet. That went on for 6 months. How can the plaintiff argue that being placed in a lit room for 3 months at age 18 doesn't cause PTSD? But being placed in a dark room for 6 months at age 8 does not cause PTSD? Now, you may be thinking, given this childhood abuse, Paua should have never placed Merrick in solitary confinement. And that makes sense. If he was traumatized from being locked in a closet when he was a child, solitary confinement probably isn't a good idea. But that's where you must remember. Pawa was unaware of this childhood abuse. Mayor Khalif never told his prison psychologist, Dr. Singh, of this childhood abuse. He only told his prison psychiatrist, Dr. Rand. And that was after he was released, after the solitary confinement already occurred. How can you blame a prison for failing to act on information that it never had? The fact is, there's only one mental health expert who met with Mr. Khalif when he was released from prison. And she said that it is impossible to determine whether or not the PTSD was caused by solitary confinement or childhood abuse. The problem for the plaintiff is that they had the burden of proving that. And that was a burden they could not meet. In their opening and closing, the plaintiff used the word worthless. Worthless? Would Pawa provide someone worthless protection when being threatened? Would Pawa provide someone worthless a personal psychiatrist for mental health problems? Would Pawa provide someone worthless a mental health reentry program even when they are no longer their responsibility? Pawa provided Mr. Khalif with treatment, protection, attention. That's not deliberate indifference. That's not negligence. That's the other half of the story. Now, at the beginning of this case, we urge you to consider both halves of the story. But there's one thing that we can all agree upon, and it's this story is filled with tragedy. Abuse of an 8-year-old boy, nightmares, flashbacks, beatings, and ultimately so much pain, so much hopelessness that the boy took his own life. We can't change that. We can't go back in time and save Mayor Khalif. But what we can do is make sure that this story does not end with injustice. Don't blame a prison for wrongs done to a young man before he ever entered their doors. And don't blame a prison for failing to act on information that it never had. We ask you to return a verdict of not liable on all 5 counts.
Thank you, counsel. Does plaintiff's counsel have a rebuttal?
Yes, Your Honor. A plaintiff requests a time check.
Time check, please.
The plaintiff has 1 minute and 50 seconds remaining.
Thank you.
All right, you may
May I proceed?
Yes, you may.
May I proceed?
Yes, you may.
Members of the jury, defense just asked you, how did the defendant treat Merrick worthless? Let me tell you. The defendants treated Merrick as worthless when they beat him, when they let others beat him. The defendants treated Merrick as worthless when they knew he had a mental disorder and put him back in the same place that caused it. The defendants treated Merrick as worthless when again and again they decided to cast aside his physical and mental needs. Members of the jury, I ask that you find them liable for their crimes against Mr. Khalif. Because to them, he was worthless.
All right, thank you. All right, this concludes the presentation, and before I dismiss the jury to the jury room, I want to give both teams a round of applause for a very fine round. All right, and so the jury may retire to the jury room, and we'll tabulate the scores. Thank you. Cool.
Awesome. So before we announce the results of the trial, let's give a round of applause for all of the competitors. It has been truly remarkable to see this case come to life, especially the parts that I had some hand in. It's just so strange to see the creative liberty that y'all took. So it was really amazing. The only other thing that we cannot announce results before we do is thanking Judge McMillan on behalf of Empire Mock Trial. We sincerely thank you for judging our final round. And as a small token of appreciation, we have a trophy for you. For presiding over the Empire Atlanta Championship round for the second time, we are so grateful for your support of legal education. Thank you so much. So this is the moment that we've all been waiting for, that we have all been here for this weekend. It was a wonderful championship round to watch. It was a battle, judges, it was a battle of the Golden State. We have two teams from California. On the plaintiff, we had Trinity Pacific Christian School hoping to capture the trifecta, their third Empire Championship. And on the defense, we had Renatus Mock Trial from Southern California, and my God, was it a great round. Your 2017 Empire Atlanta, the Southern Showdown champion, is Trinity Pacific High School.
Keep it down now. All right, everybody look. Let's see some like excitement.
Oh my god, you're ruining my video. Sorry. Boomerang. Everyone get it. Wait, Christian. How broke with that? Put it. Wait, can someone look longer? Oh, yeah. Do something like that. Boomerang. Actually, but we're going to do boomerang on. Okay, yeah, thank you. Just press it once.
Ready? Do you want, are you to be in it? They were like kind of, okay, ready? 1, 2, 3. Okay, tell me that.
Thank you. Wait, was that a boomerang? Yeah, it was a boomerang. Oh, no. Head tilt.